And just want to start with an announcement and an introduction for those of you who might not know me. My name is Mike Klinger. I'm the Work Incentive Specialist for DARS. And I wear a lot of different hats in the agency, but a big part of my job is to do technical assistance and training on federal and state work incentives and benefits for our work incentive specialist advocates and VR counselors. So I would be the person that you would contact in case you have any questions that come up relating to benefits and work incentives that you might need help in answering. So that's just a quick introduction. And if you are a VR counselor, which most of you on the line are, I just want you to know that CRCs are available for your participation today in this webinar and for all the following up webinars as well. Each webinar is going to be held on Thursdays from 1 to 2:30 over a 6-week period, and CRC credits are going to be available for those as well. If you can't make them all, don't worry. All the webinars are going to be recorded in archive, so if you miss one, an archive will be available for you to listen to later. If you do require CRCs, just shoot me an email after the training at Michael, M-I-C-H-A-E-L, .Klinger, K-L-I-N-G-E-R, at dars.virginia.gov, and I will be glad to make sure that those get logged in for you. So what I have up on my screen now is a PowerPoint that I developed. We'll be using the same PowerPoint for each of the webinars. It's broken down into 6 modules. And I sent it out to everybody that was registered as of 11:30. So if you registered after that, you might not have this. If you don't have it and you still need it, just shoot me an email afterwards and I'll be glad to get it to you. But this webinar series is going to be on the basics of SSI, Supplemental Security Income, and SSDI, Social Security Disability Insurance. And a lot of the information is going to be pretty basic. I'm kind of starting at square one because when I got a request to do this, a lot of the counselors that asked me to do it asked for like a general basic overview. So if you have heard some of this information before, I apologize. We're just going to start with the basics. So the first slide is just a comparison between the 2 disability programs and how they are similar and as well as how they differ. So you'll notice that on the first slide, the only thing that the 2 programs really have in common is that for both programs, people have to meet Social Security's definition of disability. And I'll talk a little bit about what that constitutes in just a minute. But for supplemental security income, or SSI, you'll notice that a client must have limited income and resources at the time they apply for those benefits. And I'll go through the actual limits in a minute. But essentially, for somebody to be on SSI, they have to be low income. The payment rates for somebody that qualifies for SSI vary based on their living arrangement and the federal cost of living. And people that are SSI recipients are also eligible for Medicaid, or the health insurance for people with disabilities and who have low income. Now, in some states, if somebody's on SSI, they automatically are eligible for Medicaid. In Virginia, it works a little bit differently. In Virginia, a person on SSI meets all the criteria for Medicaid, but they are required to contact their local Department of Social Services to actually file an application. It's not automatic. They have to apply for it. And I'll talk about each one of these things in more detail as we go along. On the SSDI side of things, things work a lot differently. They still have to meet Social Security's definition of disability, but there are no income and resource limits once a person is found eligible for SSDI. And there are no set payment rates. Unlike SSI that's based on living arrangement, SSDI is based on a client's work activity. So as a general rule, payment rates are determined by how long a person has worked and how much they paid in Social Security taxes during their working career. So the longer that a person worked, the more they pay in taxes, the higher their benefits are going to be when they get approved for the SSDI. And then SSDI recipients are eligible for Medicare after 2 years or 24 months of getting an SSDI check. And again, we'll talk a little bit more about that later. So what's SSA's definition of disability? And this is a definition that people have to meet if they're on or applying for both SSI or SSDI. So Social Security defines it as a client that has an impairment that's expected to last at least 12 months or end in death. So they have to be disabled for at least a year in order to meet Social Security's definition of disability or have a terminal illness. So, for example, if somebody just broke their leg, that wouldn't meet the duration requirement because that's not going to be a disability that lasts at least 12 months. So that's number one. Number two, there's a specific threshold that a client cannot be making more than if they're working when they apply for either SSI or SSDI. So they can't be grossing more than $1,180 a month in 2018 when they apply for benefits. If they are making more than that, Social Security would deny their application because they would say, even if they meet the duration requirement, that they're not disabled because they're making more money than the allowed limit. Also, if they're applying for SSI, in addition to meeting that $1,180 threshold, they also cannot have resources that exceed $2,000 at the time they apply. If they do, their application would be denied regardless of their disability. And I'll talk a little bit more about resources when we get to that slide. So what are the supplemental security income or SSI payment rates? And basically, just real quick, it's called supplemental security income because it's meant to supplement other forms of income that a person has coming in, whether it be wages or SSDI or a private pension or something else. It's not meant to be a client's total source of income. You may have clients whose income is only SSI, but it's really meant to supplement other forms of income. But like I mentioned earlier, the payment rates are based on the federal cost of living figures and the person's living arrangement. If there's a cost of living increase that's announced by the government, generally SSI check increases every January 1st. So if it's going to go up this year, we'll probably be seeing an announcement from Social Security probably late October, early November with the 2019 SSI payment rates. In the past, historically, it's been about 2%. So not a whole lot of increase, but it will go up if the cost of living goes up. For 2018, if a person is living alone, the maximum they're eligible for is $750. If they're living with others and not paying their fair share of expenses, and I'll talk about that in a minute, their payment rate is reduced by 1/3, so the maximum they're eligible for is $500. And then if you have a disabled couple, that limit is $1,125. That's the maximum SSI that a couple can receive. And to get the couple rate, both people have to be disabled in the married couple, and both have to be SSI eligible to receive that combined couple rate. Oh, and I forgot to mention too that I will answer questions at the end. So if you have a question, please just hold them. You can type them in the chat box once I get through all the slides. Thanks. So the way that Social Security figures out what a client's payment rate should be, like I said, is based on their payment arrangements. So a person living alone, like I said, is eligible for $750. But if they're living with other people, they're going to have their payment reduced by 1/3 to $500 unless they can document to Social Security that they're paying their fair share of expenses. And the way that Social Security determines whether or not a client is doing that is by looking at the total cost of the shelter and food expenses for the household and dividing that number by the number of people that are in it. So, for example, if a client is living in a household with another person, then Social Security would expect that client to pay half of the expenses related to food and shelter. Or if there were 3 people living in the household, they would have to pay 1/3 of that, and so on and so on. So if a client is getting a reduced payment rate, but they are paying their fair share of expenses and can document that, what they would want to do is go to Social Security with a statement showing how much they pay for their housing and food costs, and then Social Security could potentially increase their rate to the whole $750. If it's not possible for a client to meet their fair share of expenses on an SSI check, let's say, for example, there's 2 people living in a household, the client's half would be $1,000. Obviously, they can't pay that on a $750 SSI check, so they would be subject to a lower rate. But that's how Social Security determines, based on living arrangement, how much they should be getting. Mentioned a little while ago that when a client applies, as well as an ongoing basis, even after they're found eligible for SSI, their resources have to be within a $2,000 resource limit. And there are several different things that Social Security counts as resources. And a resource is generally defined as anything that's cash or can be converted into cash that a client could use to pay for food and shelter. And the reason why resources matter is, remember that supplemental security income is meant to supplement other forms of income and resources that a client has. So if they have substantial resources, like over the $2,000 limit, Social Security is going to say, well, you don't need an SSI because you have resources. So these are some of the things that Social Security will look at when a person applies, as well as ongoing. How much a client has in a checking account, a savings account, a stock, a bond, a burial account in excess of $1,500. If a person has a burial account, the first $1,500 of that is excluded, and then anything above that would count towards the $2,000 resource limit. And they also look at things like 401ks or other retirement accounts, depending on the circumstances. Whether or not that's going to count is going to depend on whether or not a client can access their retirement early. If they can't, like if they have to wait until they retire, or if they leave a company to access their 401k funds, then it wouldn't count towards the resource limit because they can't touch that money yet. But if it was a situation where they could maybe borrow against the 401k and access the money early before they retired or leave their employment, then it could count against the resource limit because they have that money in hand. And there are some accounts that are available to people with disabilities to access early without penalty. So what I always tell people, if they have a 401k and they have a question about whether or not it counts, the best thing to do is to talk to their claims representative at Social Security, tell them that they're looking at maybe withdrawing some of their 401k early, and then talk to that claims rep about how that's going to impact their benefits, or if it would or not. Social Security is always the final authority in matters like that, so whenever clients have questions, they really should consult Social Security first before they make any decisions. Excuse me, I just need to take a drink. So even though there are some resources that Social Security counts towards the $2,000 limit, there are also some resource exclusions, things that Social Security would not count in determining whether a client is eligible for SSI payments. So the client's home and the land it's on is totally excluded from that resource limit regardless of value. And I should note there that only the home is excluded only if it's the client's primary residence. So the client has to be living in the home in order for the value to be excluded. If a client had more than one home, the value of the home that they're not living in would count towards that resource limit and could make them ineligible for SSI. Now, if they're on SSI and they have low income, it's, odds are that they're not going to have more than one home, but a person could. But the value of the home and the land it's on, as long as the person's living there, does not count against the resource limit. One vehicle, regardless of value, is also excluded. So Social Security wouldn't count the value of a vehicle that a client had against that resource limit, regardless of how much it was worth. Somebody could be driving around in a BMW and it wouldn't matter as long as it was the only vehicle. Only time that a vehicle would be considered against the resource limit is if a client had more than one. Tax refunds are not counted as part of that resource limit because it's a one-time thing they get at tax time. And Missy, I see your hand. I'm going to hold questions until the end, though, just so I can get through all the slides, but I will get to your question. So tax refunds are excluded regardless of the value because it's not a regular ongoing payment that the person receives. It's a one-time a year refund, and so Social Security doesn't count that against the resource limit. The property used that a client uses to run a business, any of the buildings on the property or the property itself is disregarded. So an example of that would be, let's say somebody was self-employed and they were a farmer. The value of that farm is excluded regardless of value because they use that land to make their money. That's their source of income. So it's called property essential to self-support. Social Security would not count that property. And then money in achieving a better life experience or ABLE account. I'm not going to go into that now because I'm going to cover ABLE in depth in a future webinar. But any money that is put into an ABLE account can be excluded, and we'll talk about that in a few weeks when we get to that webinar. So I wanted to talk to you a little bit about Medicaid and SSI. And like I said, if somebody is on SSI, they automatically meet the income and resource criteria for Medicaid. They're eligible for it. All they have to do is make contact with their local Department of Social Services, or they can apply for Medicaid online through Virginia's Common Help portal and fill out an application that way. But all they need to do is contact DSS and file that application. Medicaid is, which some of you might know, health insurance for people that are senior citizens or with disabilities, or for pregnant women or children with low income. For a lot of the Medicaid programs, there is no premium. And it covers things like medical services, doctor's appointments, hospital stays, medications that a client might need to manage their conditions, durable medical equipment like walkers, wheelchairs, crutches, things like that are all covered under Medicaid. Again, if they're on SSI, they have no premium. It's cost-free health insurance. And as long as a person has at least $1 in SSI, regardless of how much they work and regardless of how much they earn, as long as their SSI payment is at least $1, they're automatically covered under Medicaid as long as they have that SSI benefit. Okay, now onto the Social Security Disability or SSDI side. There is no limit on resources. So unlike SSI that has a $2,000 resource limit at the time they apply and ongoing, there's no limit on resources for SSDI. So somebody could potentially be a millionaire and still qualify for SSDI. They just have to still meet that 12-month duration requirement in terms of disability. There are limits on how much a person can earn when they're on SSDI. As a general rule, if somebody is not blind and they just have another kind of disability, whether it be physical, mental, or emotional, they can work, but they can't earn more than $1,180 gross pay as a general rule without impacting their eligibility for the SSDI benefits. Now, there are some work incentives that can reduce the amount of money that Social Security counts when the client goes to work. Not going to go into them today because that's a future webinar as well. But that's just something to be aware of, that that's kind of the magic number. And for SSDI, a person is either eligible for their whole check or nothing at all. There's no gradual reduction. So if they're working and they're making less than $1,180 a month, then they're eligible for the whole check. If they make over that, then they're eligible for none of the check for the month they exceed that limit. There's no limits on unearned income, though. There's only limits on wages. So the client can have as much unearned income as they want and still qualify for SSDI. Unearned income is anything that's not wages, like a pension plan or a VA benefit. SSI benefits are not counted as earned income. That would be unearned income. So there's no limit on the amount of unearned income that the person has. There's only a limit on the wages. And the other difference between SSI and SSDI is that with SSI, only the person that has the disability can receive those payments. There's nobody else paid on that record. But for SSDI, it works a little bit differently. So in addition to the client who has the disability being eligible for SSDI payments, other people can also get payments on that record. So an example might be a disabled child of the worker who has been disabled prior to age 22. They could potentially also get benefits on that client's record. The client's spouse, could be eligible for some benefits in some certain situation. Even if the client doesn't have any disabled children, but they have minor children under 18, those benefits could be payable to minor children until they turn 18. So SSI, only the person with the disability can receive that money, but SSDI, there's additional benefits that can be paid to a spouse or a minor child or a child with a disability. And the reason why Social Security allows benefits to be payable is because, like I said, to be eligible for SSDI, a client has to work enough and pay enough into the system to be insured for those benefits. So because they've worked and they've paid Social Security taxes, it allows others that are dependent on that worker for support to also be eligible for benefits. And as a general rule, Social Security considers a person who has worked at least 5 out of the last 10 years to be eligible to have enough of a work history to be eligible for SSDI benefits. And even though the person who is working has to have a work history to qualify for the SSDI, the spouse necessarily doesn't, or the disabled children necessarily don't have to have a work history to qualify for benefits on that person's record. As long as the worker is eligible for SSDI, the dependents could be too, regardless of whether they work or not. So, like I said, with SSI comes Medicaid, with SSDI comes Medicare. It's not automatic. For SSI, somebody could apply for Medicaid. It probably would kick in probably within about 30 days. For SSDI and Medicare, there's a little bit more of a waiting period. That requires that a person gets at least 24 SSDI payments before the Medicare kicks in. It's called the Medicare waiting period. And mostly everybody has to serve that, with a couple exceptions. The waiting period is waived if somebody is terminally ill with certain things. One of the ones that comes to mind off the top of my head is like if somebody has end-stage renal disease, where they have kidney failure, then they could get the Medicare right away. Certain types of cancers, if the client isn't expected to have a great prognosis and live past that 24 months, they could potentially get Medicare sooner. But usually the only exceptions to that 24 months waiting period is a fatal illness. Most people have to serve that before they can have their Medicare kick in. Unlike Medicaid, there is a monthly premium required for certain parts of SSDI, or certain parts of Medicare, excuse me. There are a couple different parts to Medicare, and I didn't put them all on the slide, but Part A is the hospital insurance. It covers any kind of hospital stays or surgeries, things of that nature that a client might have, and that is premium free. That typically doesn't cost anything. That's covered because the client has worked enough and paid enough in Medicare taxes over their working career to be eligible for that. What they're going to pay for is Medicare Part B. And Medicare Part B is everything other than hospital. So it covers things like doctor's visits, durable medical equipment, things of that nature. Anything related to something out of the hospital. Outpatient surgeries, that type of stuff would all be covered under Part B. For 2018, that premium is $134 a month. And usually what will happen is if a client is getting SSD benefits, Social Security will set it up so that that $134 is automatically deducted from the check. If a client is not receiving benefits but still entitled to Medicare, usually what they'll do is they'll bill them every 3 months for the premiums. Now, if a person is low income, or if they're on SSI and Medicaid as well as Medicare, Medicaid will actually pay that $130 premium for them. So not everybody you're working with is always going to see the $134 premium, even if they have the Medicare just based on their income. The state can kind of pick that up for them in some circumstances. And unlike Medicaid, that generally covers 100% of services, if a person goes to a provider that accepts Medicaid, Medicare generally only covers about 80%. So it's not going to cover everything that the client needs. It only covers about 80%, and then the client would be responsible for the other 20. So, you know, they might have a copayment when they go to the doctor, or when they purchase a wheelchair, or whatever they're using the coverage for. They could be responsible for a 20% copayment there. Excuse me, I need another drink. Sorry, sometimes my voice gets hoarse when I speak. So just wanted to quickly talk to you a little bit about the application procedure, how one would actually go about applying for benefits. And the application procedure is the same for both programs. The rules about how they look at income and resources are a little bit different. But for both SSI and SSDI, a client has to fill out an application and a disability report. There's a two-part application process. And the disability report can be done online at ssa.gov, and the application for SSDI can be done online. But if a client wants to apply for SSI or another form of benefits, like if they have a disabled child, that application needs to be done at a Social Security office or over the phone. So there's a two-part application process. And the disability report gathers information on things like what the client's disability is, how it limits their ability to work. It asks them to list any medical treatment that they've received, you know, doctors' names, have they haven't had any surgeries, if so, where have they had them, you know, do they take any medication for their disability or to manage their symptoms, that sort of stuff. All that information goes on the disability report. And then Social Security can help a client gather any medical evidence they might not already have. So it's not necessary for a client to have all their medical records or provide all their medical records at the time they apply for the benefits. What Social Security will do is when they get that disability report with all the doctors' names or, you know, everything on it, they'll send a client some release forms. The client will sign them, send them back to Social Security, and then Social Security can contact the medical providers and get that information for them. So clients don't have to worry about that. Social Security will help them gather medical evidence they might not have. So next slide, it kind of has to do with what a client can do and what their appeal rights are if they apply for benefits and have an application that is denied. So first of all, I would say it would take about 60 to 90 days for an initial determination to be made once a client applies for benefits. And Social Security has to Social Security has to notify, rather, the client of their decision in writing. whether it be favorable or not favorable. So that's Social Security's responsibility, is to send a client a letter. If a client gets an unfavorable decision, they have 60 days from the date on that letter telling them that they're denied to file an appeal. All right, that's a very time-sensitive thing. So a client has to respond within 60 days to request their appeal. If they miss the 60-day deadline, Social Security could deny their request for an appeal unless they have a good cause. A good cause for meeting a deadline would be something like, well, I was in the hospital, I was very sick, I couldn't get my appeal in within the 60-day deadline, or, my house burned down or something tragic happened. Social Security can be a little bit lenient on that. But without good cause, they have to appeal within 60 days. And so to appeal that, they have to fill out a form that's called a request for a hearing in front of an administrative law judge. And that's a simple one-page form that a client can use just to explain why they disagree with the decision. So, for example, if somebody said, I'm applying for disability because I'm bipolar, and Social Security says, well, okay, you might have bipolar, but we think you can still work and your application's denied. One of the things they might write on the appeal form is, I disagree with the determination. I feel like I meet your definition of disability because, on days where my bipolar is bad, I can't get out of bed in the morning. And I can't hold a job because, I've lost jobs because I'm not dependable because of my depression. And I've been fired from 5 jobs in 5 years, something like that. They would just explain why they feel that they are not, that they are eligible for benefits and want to appeal the decision. And in my experience, most of the time when a client does apply for benefits, a lot of clients will get denied the first time. That's just to be expected, unless they have a disability that is so severe and so clear that they're not able to work or work at a substantial level, that they might get approved the first time. But a lot of clients do get denied and have to appeal it. In one of my former jobs, part of my job was actually to help people apply for benefits. And in my experience, I had a handful of cases that I helped clients apply where they did get approved the first time, but that was few and far between. Most of them came back to me wanting help with the appeal paperwork. And unfortunately, the hearings are kind of backlogged right now. A general time frame for a hearing date to come up is usually within 2 years. So even though a client has to respond within 60 days of their denial requesting the hearing, it could take up to 2 years and sometimes longer for a client to actually get a hearing. And actually, that's on the next slide. So what will happen at the hearing is that the judge will take a look at the initial determination and any medical records that the client has submitted previously to support their claim. And also, if they have any additional medical evidence that they've obtained since they've been waiting for the hearing, the judge will look at that too. So let's say, for example, somebody had got denied, requested a hearing, and then had a surgery a year later, and that surgery wasn't part of the initial decision. The judge will look at any new medical evidence in addition to any medical evidence that the client has previously submitted to determine if they are eligible. So if benefits are awarded upon appeal, the client will be entitled to benefits for the time that they've been waiting. All right. So, for example, if a person applies, let's say they apply this month in August of 2018, they get denied, they request a hearing, and then the judge says, well, I find that based on your medical evidence, you should have been receiving benefits since August of 2018 when you first applied. Social Security will actually pay the client back all the benefits for the time that they were due while they were waiting for the hearing. So it can be quite a big financial windfall for clients if they do successfully win an appeal, because it could be a large amount of money depending on how much they were supposed to get every month. Now, if somebody is on SSI and they get back pay like that, it's not counted towards the $2,000 resource limit. I think they have 9 months from the time they get it to actually spend it down below the $2,000 limit. And then on SSDI, it doesn't matter how much the back pay is because, again, there's no resource limit. But it doesn't necessarily always end there. In my experience, a lot of the appeals that clients have filed with an administrative law judge have been successfully overturned, and the judge will award benefits. But if the ALJ upholds the previous decision, if he thinks or she thinks that the client is not eligible for benefits, they will deny the case again. And the appeals process will kind of start over at that point. The ALJ will have to notify the client in writing saying, we've reviewed your case and we determined that you're not disabled, your appeal has been denied. Then they have 60 days from the date of that determination to appeal further. The next step is the appeals council. And the appeals council is just made up of a panel of different judges that will look at all the medical evidence, look at the initial determination, look at the decision made by the administrative law judge, and then determine whether or not the decision stands. And finally, if the appeals council still denies it, then the last option would be for the client to appeal in federal court. So there's various different levels of appeal. And if you have a client that's in a situation where they want help with an appeal, my advice would be to refer them to the local legal aid society, especially if they're on SSDI and have limited income or SSI and have limited income and resources. A lot of the time, the legal aid society can provide pro bono services and legal representation if a client has to go to a hearing. Now, it's not required that a client gets a lawyer. They can do all the appeals procedures themselves, and they can represent themselves in court. But because the lawyers know all the rules and the regulations, it's always best. I would always recommend to my clients that they seek representation. Okay. And that was pretty much it for the material for webinar 1, and it didn't take me as long as I thought to go through it. I've only been talking for about 40 minutes. So what I want to do now is ask if anybody has any questions. You guys are in listen-only mode, so if you want to just type in the chat box. And I see that somebody typed in the chat box that the reception is spotty and the audio keeps cutting out. I apologize for that. My internet service has been down for quite some time, and I actually borrowed a T-Mobile hotspot in order to do this webinar. So this isn't my normal service. Hopefully you could follow it okay, and I'm sorry that it's not the greatest audio quality. give you a couple more minutes to type in any questions. Okay, Linda asks a question. I may have missed this if it was in the beginning, but is the age requirements for SSI under 18 and SSDI over 18? And so I'll answer the first part of that first. So for SSI, a client could either be both under 18 and over 18. The only difference is that if a client is under 18, there's a different standard for eligibility. The way that it works for a child that's under 18 is that Social Security will look at whether or not their disability limits their activities of daily living. So in other words, do they have issues with or need help with things like bathing, dressing, eating? Do they have learning disabilities? Are they in special education in school? Do they learn at a slower pace than the other kids their age? Those kinds of things will be what Social Security looks at in determining eligibility for children under the age of 18. If a client is on SSI when they turn 18, Social Security will do what they call an age 18 redetermination. And at that point, Social Security will go back and look at the medical records that's in the client's file and determine if they're still eligible for SSI benefits. And the definition of what constitutes a disability at that point kind of changes. So previous to age 18, they look at limitations in terms of everyday living. And then over 18, they look at whether or not a client is capable of working and earning a substantial living, more than $1,180 a month. So basically what changes when they turn 18 is Social Security looks at whether or not the disability that the person has limits them in terms of being able to work or be able to work substantially. So sometimes you might have a client that was on SSI prior to age 18, and then Social Security will review the record and then determine they're no longer disabled because they'll say something like, well, you have a disability and you were entitled as a child, but now that we're looking at your work, we find that your disability isn't limited enough to keep you from working. And so they might lose benefits at that point. That's actually pretty common. So that's kind of what's different, the change in the definition. SSDI, yes, they would have to be over 18 because SSDI is based on work history. And like I said, you might have missed this at the beginning, so that the more that the client works and pays in Social Security taxes, the higher their SSDI check is when they start receiving benefits. So people that are on SSDI would have to be over 18 to establish that work history. Or I talked a little bit about a dependent that has a deceased, disabled, or retired parent. They might be able to get benefits on the parent's record without a work history, but they would still need to be age 18 or more to qualify for those. So yes, it's over 18 for SSDI. And the other part of your question, Linda, was also, are the requirements for somebody who is retiring different for SSI than somebody with a disability that you spoke of today? Yes, a little bit different. So when somebody is age 65 or over, they are also entitled to SSI payments if their income and resources are low enough. The difference is between a disabled person and a person that's getting SSI on 65 or older based on age is that the person that's 65 or over doesn't necessarily have to be disabled. They just have to be 65 or older. So it is a little bit different in that regard, but the income and resource guidelines are the same. So the person would still have to keep their resources within the $2,000 resource limit. They still can have only limited income. They still have to meet that criteria. So it is the same and also a little bit different. And then Anne Marie has a question. During trial work period, are the limits to what an SSI recipient can earn? Okay, Anne Marie, and I will talk a little bit more about trial work period in an upcoming webinar, but just to answer your question now briefly, no, if a person is in their trial work period on SSDI, they can earn as much as they want during that period without impact to their benefits. So that's a period where a person on SSDI could work as much as they want, bank as much as they want, test their ability to work, see if they can do it. And if they can't and they have to quit the job, then they're out nothing, because they do have that period where they don't have to worry about losing benefits. And we'll talk more about that in a couple weeks when we get to the webinar on SSDI work incentives. Okay, and it looks like that's it for the questions so far. Did that help clarify your questions, Linda and Anne Marie? You have any others? Okay, Linda says yes, thank you, no problem. Any other questions, concerns, or comments? Oh, okay. Okay, Anne Marie, I do see your other question now. You asked, so during the trial work period, are there limits to what an SSDI recipient can earn? I have a client with ALS who is 21 and who is in college. Can she still apply for SSDI? So I answered the first part of your question. The second part of it, this client on ALS, who's 21 in college, she can apply for SSI. It's going to depend on whether or not she's working. If she's working, she can't make more than $1,180 a month, and she can't have more than $2,000 in resources, which I went over a couple slides ago. Resources are like checking accounts, savings accounts, stocks, bonds, 401k. But as long as she meets the disability requirement and her income and resources are within the guidelines, then absolutely she could potentially qualify for SSI. And unfortunately, and I don't mean this to sound terrible, but because ALS is such a progressive and serious disease, it would probably be easier for somebody like her to get on benefits the first time, because it is something that's very clear that it impacts her ability to work. So, she might actually be a more feasible candidate for SSI benefits than somebody that just says, maybe I can't work because I have a back injury or something like that. So yeah, I would definitely encourage her to do that. All right. Well, if there are no other questions, I will go ahead and end for today. I had this scheduled for 2:30, but I just always do it a little bit longer because I never know how long it's going to take me to get through the slides or answer all the questions. So I don't think we're going to need all that time. I'll go ahead and end, and I will send this archive out to everybody. Again, just a reminder, if you need CRC credits, or if you need a copy of this PowerPoint, if you don't already have it, shoot me an email, Michael, MICHAEL.Klinger, KLINGER, at dars.virginia.gov. Be glad to get that for you. Oh, hold on, I got one more question from Anne Marie. She isn't working now, but after college she wants to, but her income couldn't be over 1,180. All right, so yes and no. It can't be over 1,180 at the time she applies for SSI benefits, but once she's found eligible for benefits, she could potentially make more than that and still qualify. If you're looking at SSI only, Social Security only holds clients that income standard at the time they apply. The rules are a little bit different once they're on benefits. This year, a client can make just over $1,500 on SSI and still receive a small cash check. So as long as she's not taking over that now, and as long as she wouldn't be working until after she graduates, if she's already on benefits when she begins to work, she's good to go. She can make more than that. Does that help? Okay, great. All right, everybody. Well, the next webinar is going to be on next Thursday, would be September 6th, again, from 1 to 2:30. And during that webinar, I'm going to be talking to you a little bit about what happens to a person's SSI benefits when they go to work, how that work activity impacts the benefits, and how Social Security counts income. So hope you'll be able to join me, and I will talk to you then. I thank you for your time, attendance, and participation today, and shoot me an email if you need a copy of the PowerPoint or the CRCs. Thank you, everybody. Bye-bye.